So from the 19th century, yoking business and state power to education, which reduced emphasis on reason and logic and placed more on immediate utility of workers to a certain trade. For instance, the coal industry in Britain. Then the world in the 20th century went through different forms of authoritarian or totalitarian forms of government based on totalitarian concepts of reforming people to serve capital in various ways, as I said, This is down to competing power bases and groups wanting inordinate influence because no one group dominates. There are attempts to subvert reason and the democratic process as the end of the encapsulation. For instance, a lawyer cannot consider ethics or morality in defending his or her client, only what the law states is appropriate representation. This is to prevent lawyers taking cases where there may be moral hazard that undermines the principle of innocence until proven guilty by a court of your peers. Those peers being under the principle of the reasonable person, just as in self-defense cases it is by the marker what is apt in the context at the time. That's the foundation of what a reasonable person action or expression, is. A perfect example of this is the case that Schenck versus US is about. This that you did in your excellent video. The spirit of the law is always important, or judges can, for personal bias or reasons outside the case, such as corruption. Some judges are and have been part of criminal organisations. For instance, in some states, the criminal organisation has co-opted the state's power to coerce so much that it is no longer reasonable to call the state's monopoly on force authority, but just tyrannical coercion. Take your pick from the horrors of history. In America's own history in 1776, people made that judgment that that's what had happened, and that that there needed to be a revolution. And in Saudi Arabia today, you have the Saudi Bandar and Bin Laden crime families dominating the power in the state. For instance, if we take the US Constitution as the highest law of the US and its citizens, and it is the citizens' manual of rights, duties and obligations to each other, as well as a check on the state and business powers, the money power that Jefferson talks about, becoming its own agent and not a servant of the citizens and national society. This is why, even more so than Jefferson, Thomas Paine, absolutely in the rights of man and common sense, and his assistance in writing, or the joint effort between him and Jefferson in writing the US Constitution, that liberty and equality must be balanced. That is where we derive social from, because of course they were both Epicureans, Stoic and Epicurean philosophy is what builds on the idea of society, what is social, what is national, what is nationalism in the sense. The tempering of those concepts is that you have, as Thomas Paine and Jefferson put, you have a respect for natural rights and your duties to each other as fellow citizens to help each other assert those rights rather than limit or stop the assertion of rights. That is how you get constitutional nationalism as it was in 1776. Okay. The US Constitution is the highest law, and citizen's manual, and the obligations to each other, as well as a check on the state or business power becoming its own agent and not servant of the citizen and national society, community. The Constitution is clear that the First Amendment and Second Amendment are mutually supportive. This is not my argument for firearms being illegal, but a principle of equality of force and balance between the nation and the state, i.e., the nation and the state have a duopoly of the ability to use force, right? In totalitarian states, there is a monopoly on the use of force, whereas in a nation state, the state serves the citizen and the nation, right? That there be no private good before national good or public good, okay? And that is why the principle of equality of force is shared between the nation state, the nation and the nation state. So the equality of force principle and the balance between the nation and the state. For instance, most people in England do not carry firearms, so neither do the police. If the police became a criminal tyranny, as happened in the past, i.e. Roman history is full of examples, as I said in my other video, then the people can say, we do not consent to this coercion, and could choose to resist. It is this principle that a well-regulated militia is to uphold the assertion of freedom, right, and liberty of expression and domestic tranquility built into the US Armed Forces, stating an oath to uphold the Constitution against all enemies, foreign and domestic. It obviously was not saying that any group that makes itself the state as the self-given privilege to stop the rights of all the other citizens being asserted, so long as they are not breaking rational ethical laws, which are based on the principle of consent, derived from those laws being based on general cultural norms. There's a general cultural norm that rape and murder are bad things, so that's why those laws were derived to prevent those things from happening. And why are they bad things? Because no one can consent to being murdered or raped. So that's the end of the encapsulation there. So on these principles, Schenk's intention in Schenck versus US, his intention was certainly to prevent the loss of life to his fellow citizens and the nation, and as the nation is a community of citizens, to prevent harm to the national interest. Whatever geopolitical context it was in, the law, from your reading of it, does not seem to uphold that he, Schenck, intends to do anyone harm or cause panic. If German agents who bombed the docks in US were guilty of co-opting in World War One, were guilty of co-opting Schenck to do that in German interests, that's a different and hypothetical situation which didn't actually happen. Do you think that judges should not take account of the context of what the that judges should not take account of the context of what the government of the time wants? That is outside the remit of the court, as the judge is a separate power from the executive, as stated in the US Constitution. If the judge interprets what he believes the government wants out of bias for or against, he or she, the judge, is setting precedent outside the appropriate and immediate facts of the case and subjecting the innocent accused man or woman to arbitrary state power, which is going to prejudice the fairness and outcome of the trial, besides being an organised crime against that individual and the nation and citizen society as a whole.